Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we cover the Supreme Court opinion Rico versus United States, decided March 25, 2026, by an 8-1 vote. Justice Gorsuch authored the majority opinion, joined by 7 colleagues. The lone dissenter, Justice Alito, writing alone.
Here's the bottom line up front. The Supreme Court ruled that federal courts cannot automatically extend a defendant's supervised release, the government-supervised period of freedom after prison, just because that defendant disappeared and stopped checking in with a probation officer. The Sentencing Reform Act of 1984 simply does not authorize that automatic extension.
And this matters for a lot of people. Thousands of federal defendants currently serve terms of supervised release. This decision sets a uniform national rule on what courts can and cannot do when a defendant goes on the run.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know. The human being at the center of this case, Isabel Rico. Her story goes back to 2010. A federal court convicted her of drug trafficking and sentenced her to 7 years in federal prison, followed by 4 years of supervised release. Supervised release? Picture it like parole. You walk out of prison, but the government still watches you. You check in with a probation officer. You follow specific court-ordered rules. You notify your probation officer if you move. You commit no new crimes.
Freedom, but with strings attached.
Exactly. Rico left prison in January 2017 and almost immediately violated her conditions. The judge revoked her release, sent her back to prison for 2 months, and reset her supervised release clock with a fresh 42-month term, set to expire in June 2021. Mark that date. It becomes everything in this case.
June 2021. Got it.
She left prison again in December 2017. Within months, she changed her residence without telling her probation officer. Another violation. A judge issued an arrest warrant in May 2018. Federal authorities didn't find her until January 2023. Nearly 5 years later. During those years, Rico committed more crimes. In January 2021, state authorities arrested her for evading police and driving without a license. In January 2022, prosecutors charged her with possessing illegal drugs for sale. Both cases produced convictions. So when federal authorities finally caught up with her in 2023, they brought her back into federal court with a whole list of problems.
Right. The judge classified Rico's failure to report and her January 2021 offenses as Grade C violations, the least serious category, each carrying an advisory sentencing range of 8 to 14 months. But he also classified Rico's January 2022 drug offense as a Grade A violation, reserved for conduct like drug felonies, carrying an advisory range of 33 to 36 months. After weighing everything and varying downward, the judge sentenced Rico to 16 months of additional incarceration, plus a new 2-year supervised release term. Rico appealed, arguing the January 2022 drug offense happened after her supervised release expired in June 2021, so the court had no authority to treat it as a violation.
Walk me through how this moved through the courts.
The federal district court sided with the government. Rico took that to the Ninth Circuit Court of Appeals. The Ninth Circuit agreed with the government, reasoning that Rico's abscondment legally paused, her supervised release clock. So even though the court order said her supervised release expired in June 2021, the Ninth Circuit said the clock paused when Rico disappeared in 2018 and resumed only when authorities found her in 2023.
So from the Ninth Circuit's view, Rico never actually finished her supervised release term.
Exactly, making her January 2022 drug offense a valid violation. The problem, the First and 11th Circuits rejected that automatic extension approach. That conflict, what lawyers call a circuit split, attracted the Supreme Court's attention. The court heard arguments in November 2025 and decided the case on March 25, 2026.
The crucial legal question: does the Sentencing Reform Act of 1984 authorize courts to automatically extend a supervised release term because a defendant absconded?
In plain English, when someone on supervised release disappears, does the law let courts tack on extra time as a consequence?
That's it. If yes, a court can reach back and punish someone for conduct that occurred after their court-ordered term expired. If no, That conduct falls outside the court's authority, and any sentence based on it collapses. The Ninth Circuit said yes. The Supreme Court said no.
Walk me through the court's reasoning.
Justice Gorsuch started with the actual text of the Sentencing Reform Act. Section 3624E says supervised release starts the day the person is released from imprisonment. Section 3583B sets maximum lengths, 1, 3, or 5 years, depending on the severity of the original crime. Neither provision mentions anything about automatic extensions for abscondment.
So the starting and stopping rules exist in black and white, and neither says anything about what happens when someone runs.
Right? And Congress already gave courts specific tools to address defendants who violate conditions. Courts can revoke supervised release and send defendants back to prison. Courts can impose a fresh supervised release term afterward. Courts can even pursue revocation after a term expires, but only if a warrant or summons went out before the term ended. Congress thought about this problem and gave courts specific answers. Automatic extension just isn't one of them.
Here's where I'm having trouble following this. Why can't courts just read the power to extend into the statute as implied?
Because the Act's own extension rules close that door. Section 3583E2 lets courts extend supervised release, but only after a hearing within statutory maximums and before the term expires. The Ninth Circuit's rule skips the hearing, can push beyond the statutory maximum, and operates even after the term expires. It bypasses every limit Congress built in.
So it doesn't just lack authorization. It actively conflicts with rules Congress actually wrote.
Exactly. And the Act contains one true tolling rule. Section 3624E pauses the clock only when a defendant returns to prison for 30 or more consecutive days. That's the only clock pausing mechanism Congress created. The Ninth Circuit invented a second one Congress never wrote.
What about the government's argument that Rico received zero actual supervision during those 5 years? So she should get no credit.
Gorsuch spotted the paradox. The government simultaneously claimed Rico received no supervision, so she gets no credit toward completing her term, but also that her supervised release kept running the whole time, making her 2022 drug offense a violation. The court called this asking them to imagine Rico both off and on supervised release at the same time. It's like telling someone they didn't clock in at work, but they still owe the company 8 hours. It doesn't hold together.
And the government's historical argument about escaped prisoners?
The government invoked centuries of common law, holding that an escaped prisoner's time on the run doesn't count toward completing a prison sentence. Gorsuch accepted the premise, but rejected the conclusion. An escaped prisoner stops serving his sentence the moment he flees. A defendant who absconds from supervised release never stops serving it. She remains bound by every condition and faces punishment for every rule she breaks. The common law escape rule pauses the clock. The Ninth Circuit's rule extends the total period and adds new punishment. Those are fundamentally different things. It's like the difference between pausing a contract and unilaterally extending it.
Pausing it, one thing. Extending it without any statutory authorization, something else entirely.
The court reversed the Ninth Circuit by an 8-1 vote and sent the case back for resentencing.
8-1, decisive, and across ideological lines. Roberts, Thomas, Sotomayor, Kagan, Kavanaugh, Barrett, Jackson, all joining Gorsuch.
Tell me about Alito's dissent.
Alito took a very different approach, and he opened by calling the case much simpler than the court's opinion suggests. His argument, the majority never needed to decide the tolling question at all. Alito argued that even under the majority's own framework, the district court's 16-month sentence could stand on completely different legal ground. Here's why. The Sentencing Reform Act requires judges to consider a list of factors, the Section 3553A factors, when deciding on an appropriate revocation sentence. Those factors include deterrence, protection of the public, and the nature and history of the defendant's conduct. Alito argued that Rico's January 2022 drug offense fits comfortably within those factors. The judge could factor in that drug crime without treating it as a formal supervised release violation at all.
So Alito's saying the judge reached the right destination by the wrong road, and there's a perfectly good road available?
Exactly. And Alito went further. The sentencing guidelines, the advisory recommendation system, function as a starting point, not a ceiling. The Supreme Court established in Rita versus United States, that's a 2007 case, that judges can impose sentences outside the recommended guidelines range when the range fails to capture the full picture. Alito said the judge here effectively did just that. Rico's sentence explicitly noted it applied regardless of the applicable sentencing guideline range.
So Alito thought no error occurred at all. Not harmless error, no error, period.
That's exactly right. And Alito took a subtle jab at the majority's reasoning by coining the phrase unsupervised, supervised release, noting that if Rico's term expired in 2021 while she remained completely off the radar, calling that period supervised release strains credibility. He pushed the logic to its extreme. Under the majority's view, he argued, a murder spree committed after the expiration of unsupervised supervised release would presumably require a judge to set that conduct aside.
That's pointed.
Sharp. But the majority responded by saying, whatever the theoretical merits of Alito's alternative approach, that's not what happened in the lower courts. The district court treated the 2022 drug offense as an independent supervised release violation. The Ninth Circuit affirmed that approach. Neither court addressed harmless error. So the Supreme Court said, send it back. Let the lower courts sort it out on remand.
Those are the two opinions. Let's get into what this actually means. So what actually changes after this decision?
For federal defendants currently serving supervised release, especially anyone who violated conditions near the end of a term, this decision opens the door to challenge sentences calculated under the now rejected Ninth Circuit or Fourth Circuit rule.
For federal prosecutors and probation officers, the urgency intensifies immediately. Under Section 3583I, prosecutors need a warrant or summons before the supervised release term ends to pursue new violations afterward. If a defendant absconds late in a term and the probation officer doesn't notice in time, the government loses that authority.
The majority basically said, that's a problem for Congress, not the courts. A direct invitation for new legislation. For ordinary people on supervised release, the expiration date on your court order means something real. Courts cannot extend it simply because you missed check-ins. But accountability for violations you committed during the term doesn't disappear if a warrant went out in time.
And nationally?
This eliminates the geographic lottery. A defendant in the Ninth Circuit who absconded faced automatic extension. A defendant in the First Circuit facing identical facts did not. From March 25, 2026 forward, the rule runs the same everywhere. Abscondment alone does not push back the supervised release expiration date.
Bottom line, the Supreme Court told federal courts they cannot invent punishment tools Congress never authorized, even when the government argues those tools would prove useful.
And it did so 8-1, cutting across ideological lines. When Gorsuch and Sotomayor and Thomas and Jackson all signed the same opinion, the Textual case was overwhelming.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. Talk to you soon.